This is 180 seconds of what you need to know from the world of litigation and investigations. Let's waste none of your precious time. This is Disputes 180.
I'm delighted to be joined today by Jumana Rahman, a colleague here at Paul Hastings. We'll be looking at shareholder disputes under English law, in particular derivative claims, and a significant recent decision of the Privy Council. Jumana, we know derivative claims are rare, they're difficult to bring, and they require the court's permission to proceed. But why is that?
Thanks, Stuart. Yes, derivative claims are unusual, and for good reason, as they challenge the fundamental rule which respects the majority's control of a company. Under English law, a derivative claim allows a shareholder to bring a claim on behalf of the company for wrongs done to the company itself. Typically, this is a claim against the company's directors. But a claimant must get the court's permission to do that by showing they are acting in good faith and that the claim is in the best interests of the company, not just their own.
Presumably to do that, a claimant would like to get access to the company's record, or maybe even legal advice provided to the company, and in particular, the directors.
Yes, that's right. To prove the wrongdoing, the documents which may be most relevant are likely to be held by the company. For a long time, there has existed a principle known as the Shareholder Rule, which allowed a shareholder, particularly in disputes like derivative actions, to seek disclosure of legal advice that the company had obtained where it related to the subject matter of the dispute. The rationale was that shareholders had a joint interest in the company's affairs or even a proprietary right to its documents. But in the case of Jardine Strategic, decided earlier this year, the Privy Council confirmed that the Shareholder Rule does not apply under English law. As the Privy Council colourfully put it, like the emperor wearing no clothes, it is time to recognise and declare that the rule is altogether unclothed. In Jardine, the court held that companies can assert privilege against their own shareholders, even in litigation, unless a specific legal exception applies. The idea that shareholders have a joint interest in company legal advice was firmly rejected. This ruling significantly affects derivative claims. It means that a shareholder can no longer rely on a presumed entitlement to see internal legal advice.
So where does that leave us?
It certainly raises the evidential challenges faced by claimants at the permission stage when they are trying to get the court's leave to proceed. Shareholders may now face real difficulty meeting this threshold, especially where wrongdoing is buried in privileged communications. It means that lawyers acting for shareholders will need to be more creative, relying on non-privileged documents, whistleblowers, board minutes, or maybe negotiated inspection rights or rights under shareholder agreements.
So the Jardine case is a reminder that while derivative claims remain a powerful tool in theory, in practice, their evidential foundations have just become a whole lot harder to establish. You'll find lots more on derivative claims and the Jardine case in the resources below. If you'd like to chat about what this could mean for you, do get in touch. We'd be delighted to talk.
And that's your 180 for today. It was brought to you by the wonderful team here at Paul Hastings in London. If you want to join a live version, we host regular events at the Paul Hastings office, including our two flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. And if you've enjoyed this edition of Disputes 180, why not look out for the next one? That way, you'll have done a full 360.